Good evening from New York. I'm Chris Hayes. We've got breaking news this evening. We have just received a shocking, if not unexpected, audacious, to my mind, lawless ruling from a federal judge in Texas appointed by Donald Trump, undoing the FDA's 23-year-old approval of mifepristone, one of the two drugs commonly used in medication abortion. Now, this pill has been safely used by millions of people across the country for decades. I'm sure people watching this program right now have used it. The one tiny shred of good news is that the judge has stayed the ruling for 7 days, giving the government time to appeal. But after 7 days, one conservative judge in Amarillo, Texas, will order that this abortion pill be taken off the shelves in every drugstore in America. Millions of people, no matter what state they live in, no matter which representative they elected, whether abortion is illegal in their state or legal in their state, will no longer have access to this care nationwide. Now, this entire case has been a transparently cynical endeavor from the beginning. The plaintiffs are anti-abortion activists that incorporated in the same town where this judge has jurisdiction shortly after Roe was struck down. This right-wing judge, Matthew Kacsmaryk, whose confirmation Democrats stalled for 2 years over his anti-LGBTQ and anti-abortion views before Trump rammed it through, is the only federal district judge in the town of Amarillo, Texas. And so the anti-abortion plaintiffs knew exactly that if they filed their suit there, they would be guaranteed to get their ally, Judge Kacsmaryk. At 45 years old, he already had a long history of right-wing conservative anti-abortion beliefs. He led the college Republicans at the very conservative Abilene Christian University, where he wrote in the school newspaper that, quote, the Democratic Party's ability to condone the federally sanctioned eradication of innocent human life is indicative of the moral ambivalence undergirding this party. This guy's a federal judge. During law school at the University of Texas, Kacsmaryk focused his attention on the legal foundations for abortion rights, attended meetings of the Conservative Federalist Society. In 2014, he went to work for a conservative legal group called the First Liberty Institute, defending clients like the Christian owners of a bakery who refused to bake a wedding cake for a same-sex couple. The following year, he became a trustee on the board of an anti-abortion organization that offers housing and adoption services to women facing unexpected pregnancies. Judge Kacsmaryk's sister told the Washington Post that his beliefs are strongly held, which I do not doubt. Here's her quote. He's very passionate about the fact that you can't preach pro-life and do nothing. Oh, I believe it. He's putting his money where his mouth is. When he got onto the federal bench, according to the Washington Post, he gave several wins for the right, including one that struck down new Biden administration protections for transgender people, another that forced thousands of asylum seekers to return to Mexico while they awaited processing. His asylum ruling was, however, overturned by the Supreme Court. Late last year, Judge Kacsmaryk also sided with a Christian father who did not want his daughters to access birth control without his permission, challenging a federal program that provides low-cost or free contraception, including to teens without parental consent. And then today, the crown jewel, he delivered the right wing precisely what they wanted on medication abortion, basically by adopting in toto the arguments of the anti-abortion plaintiffs who sought out his jurisdiction to file to make sure that it got to him. It's like an alley-oop in basketball. And then get this, okay? Now, plot twist. Also tonight, just within an hour of Judge Kacsmaryk's ruling down in Texas, a different judge in Washington state issued a dueling injunction, which directly conflicts with Kacsmaryk's ruling, says the FDA is not allowed to pull mifepristone. And the fact that these two rulings have been issued within an hour of each other and are directly contradictory means this case will almost certainly end up before the Supreme Court sooner, most likely, rather than later. But what we are seeing tonight with this wildly lawless ruling is a reminder. Striking down Roe v. Wade was never about sending abortion back to the states where the democratic process could figure it out. This case is not about whether a 23-year-old FDA approval is safe or whether the approval process for the drug was done correctly. No, obviously not. Obviously, anti-abortion forces who believe that abortion is murder won't stop, will not stop, never, until every woman and pregnant person in this country is denied access to that care. Melissa Murray is a professor of constitutional law at New York University. She clerked for Justice Sotomayor, then judge of U.S. Court of Appeals for the Second Circuit. She's the co-host of Strict Scrutiny podcast with Leah Lippman and, full disclosure, my wife, Kate Shaw. Irin Carmon is a senior correspondent for New York Magazine, who's covered the attack on reproductive rights for many years. Nancy Gertner is a former federal district judge. She's currently a senior lecturer at Harvard Law School. It's great to have you guys together under strange circumstances and scrambled together in the last few hours. Let's just start with the law here. Melissa, and then I'll go to you, Nancy Gertner, and Irin Carmon. But just what is the argument that the plaintiffs made here that the judge has adopted?
So the argument, Chris, was that when the FDA approved mifepristone 23 years ago, it did not undertake a rigorous review. And it's true, there was an abbreviated process here, but that was because the FDA was relying on over 20 years of data that had been conducted in Europe after the European Union had approved mifepristone. So it wasn't a tabula rasa. They weren't operating on a blank slate. There was plenty of evidence showing the safety of mifepristone. So the argument here is that the FDA hasn't done its due diligence. Well, that's not quite true. And indeed, if that was the case, it seems like the best time to bring that argument would have been 23 years ago as opposed to now. But here we are, and this ruling stays the FDA's approval of mifepristone, which means that in 7 days, it will not be available in the nation in order to be sold. But again, as you say, there is this conflicting ruling from the Washington District Court, which again presents a real conflict for the FDA and perhaps an invitation to the Supreme Court.
I want to ask you, Nancy, just the notion of a federal district judge giving a nationwide injunction is not new, and it's been done before. I think there's a lot of people who feel like that has it's happening more and more, and perhaps producing more problems or tension. Here we have these dueling rulings by two judges that are incommensurate with each other. As someone who had that job, what do you make, first of all, of Kacsmeric's ruling here, and what do you make of this strange situation we find ourselves in now with these irreconcilable decisions from two different judges?
Well, putting aside the nationwide injunction, Melissa's comments are very interesting. They're very interesting as if, and I mean, I agree with them, as if this were a rational decision premised on rational findings about the lack of safety of the drug. Look at the language of this decision, which is we talk about doctors as abortionists. The medication starves the unborn human until death. It resurrects the notion that what's really going on is that women terribly regret the decision to have an abortion. And in a universe in which Federalist Society judges are concerned that about administrative agencies not being, not taking care, not being careful about the science. If there is an administrative agency that is careful about the science, it's the FDA. This is not a contrivance. They have hearings, there are findings, and in this case, there's a 23-year battle. So I think that this is a complete pretext by a judge who wished to deal with unborn humans rather than medicine.
We should note that there's a footnote in which he explicitly says he will not use the term fetus, that he will use either unborn person or unborn human, specifically says that. There's also this, Irin, this is the manifest pretextual nature of this entire thing, right? They incorporate the plaintiffs in Amarillo because they got Kacsmeric there. They say they have standing because they're healthcare providers who, let me talk about the standing finding here. Why can you sue over this, right? The Medical Association's members have standing because they allege adverse events from chemical abortion drugs can overwhelm the medical system, place enormous pressure and stress on doctors during emergencies and complications. Like, this entire thing is fabricated, transparently so, and it worked, up to this point.
Well, he did what he came there to do. As you say, this is a closed loop of anti-choice propaganda. I also flagged the same phrases that Judge Gertner did. Post-abortive women and girls starves the unborn human until death. But let me just add here that for 23 years in the U.S. and longer in other jurisdictions, people have taken this pill safely. It has a safe a better safety profile than Tylenol. There is no epidemic of quote unquote post-abortive women showing up at emergency rooms such that this made-up group alleges. But maybe some of your viewers might be wondering, why are they doing this when abortion is illegal in Texas, illegal in all of these other states? They want, obviously, to limit abortion in blue states, but they also realize the power of medication abortion to flout many of these restrictions, to use the mail to empower individuals to end pregnancies on their own. They realize that it's going to be really hard to ransack the medicine cabinets of every woman, every family in America. And if they can crack down on the supply of these pills, they can further tighten the vice that is already incredibly tight of reproductive health access.
Well, one of the, I mean, to that, go ahead.
Puts the lie to the notion that we want to leave it to the states. We don't want to leave it to the states. We want to leave it to the red states, and that's all.